Fine. Check, check.
Turning them off.
Same meeting. Meeting ID.
All right, ladies and gentlemen, if we could, let's get in our seats and we'll get started here. To get us started, since we had our lunch, I'm going to ask Vice Chair Reeves if he would give us a prayer for the meal and for everybody here.
Thank you. Let us pray. Lord, we thank you for this time today. And long ago, we pray for the students, professors, everybody here on this campus. We pray for our judiciary here in our 250th anniversary as a nation. We thank you for the rule of law and three branches of government. I pray for your blessings on these proceedings. And then we'll pray. Amen.
Amen. All right. We also have the president of the college here. Would you like to say a few words before we get started? I hear you. Well, for those that we have people on Zoom that are listening in, so you have to have a microphone for them to hear you.
Well, hey, ladies and gentlemen, welcome. My name is Mike. If I haven't met you, it is such a thrill. There is a very, very sophisticated group of people. I am very intimidated right now. But thank you so much for picking us, for coming up here. We like the rain here. So sorry if we rained on your parade, but Dahlonega is just as beautiful in the rain as it is in the sunshine. And we hope you enjoy your few minutes with us. The University of North Georgia today, 21,000 students across 5 campuses. 8,000 students on this campus, 13,000 across our other 4. Cumming, Blue Ridge, Gainesville, Watkinsville, and Dahlonega. Yeah, you're looking at me like, wow, your job's interesting. It is. And so we are very privileged to serve. We are very honored that this is our oldest campus, the mothership, if you will. So welcome to a very special place with a lot of history. And as I thought about what to talk to you about, it really ties into who we are here. So in 1873, as a result of the Morrill Act of 1862, a guy named William Price, a very distinguished statesman here in Dahlonega, one of your predecessors, he was a member of the legislature. He actually fought in the Battle of the First Bull Run in Manassas on the Georgia side. Said, hey, we need a college in Dahlonega, and went over to Athens, made friends, and also made friends with the federal government because the property once occupied by the Mint. The Mint, of course, was built for the gold rush. The Mint burnt down like all buildings did back in those days, and he made it work. And today we stand in a rich tradition of the vision of William Price. And that tradition is his service, and that tradition is really based upon, 2 books that I keep on my desk. And I know you all know this stuff better than I do. I'm just an engineer and a soldier, but specifically this book here. And I am encouraged every time I read this book, because I believe the United States of America is about family. Families build tribes, tribes build communities, communities build countries and nations, and then nations govern themselves, or maybe not so much. But I think we've done a pretty good job. We can argue about that, but I think we've done a pretty good job. And this whole thing starts with we the people, we the family. And North Georgia is a family, and we work really hard in every one of our students to remind them the importance of being a member of this family we call the United States of America, and to be a good citizen of it, and to not make it about themselves. Oh, that was on cue. But make it about others. I tell students all the time, if you want to have a miserable life, make it about you. If you want to have a life of greatness, make it about others. And that's what we work really hard here on. So thank you for bringing your group here, your team, and discussing this important topic. I don't have enough brain cells to understand what y'all are going to be talking about, but I do acknowledge that it's founded in the principles of this glorious document, which outlines this great experiment, really based upon the family that we call the United States of America. And as we reap in the 250 years of our family being in existence, I just want to say thank you for what you do. Thank you for the influence you have on our students. And thank you for picking us today to have these discussions. So, Mr. Chairman, it's an honor to have you, a friend of North Georgia, and we welcome you here. And if there's anything we can do for you, please let us know. Godspeed. Go Nighthawks. Thanks for having us.
Thank you, President Shannon. The sound effects were to make you more authoritative, so. And I am an alum of North Georgia College. Enjoyed my time here a long time ago. Graduated in 1981. So good. It was good times. Enjoyed it. I know. I can't call it anything else. It just rolls off the tongue. All right. So, ladies and gentlemen, we're here today to have a discussion with the members of the Court of Appeals. We have several here. I thank all of y'all for coming up here, especially in this kind of weather. And from what I heard about the traffic conditions were coming up. So we're going to be talking about, as I understand it, the caseload of the court and other issues that may be affecting all of that. And I'm going to call on Presiding Judge Brown, or I hope I got your title right. I'm not sure I did. Trent works good? Okay.
Good afternoon to everyone. Appreciate everybody spending their time on Friday now afternoon to be here with us.
By the way, you need to, yeah.
He told me that 3 times. Yeah. But I've made notes to keep me on the path, at least as we begin. Chairman Gunner, Vice Chairman Reeves, distinguished members of the House Judiciary Committee, and honored guests, thank you for the privilege of appearing before you, this committee, this afternoon. Thank you to President Shannon and the University of North Georgia for the use of these facilities on this beautiful campus and for the efforts in making this meeting possible. We enjoy any opportunity for off-site visits to allow us to see and be seen throughout the state of Georgia. On behalf of my colleagues, we appreciate the chance to speak with you today about several important issues regarding our court. I also want to thank this committee for its interest in the Court of Appeals and for the concerns it shares regarding the retention of the talent within the Georgia Court of Appeals and being proactive in our preparation for increased caseloads. I'll start by saying that Georgia has a Court of Appeals it can be proud of. Anything you may have heard about our ability to manage a heavy workload, meet our statutory requirements in docketing and moving cases, and rank among the busiest intermediate appellate courts of our kind in the nation can only be fully appreciated from the inside. Our attorneys and staff are among the most brilliant and hardworking in state government. It is no wonder that private and public employers recruit them, and it says a great deal that so many choose to stay despite those demands. They are truly public servants. Among the issues we will discuss today, I'd like to spotlight a few in the beginning. First is our ability to retain the brilliant staff we already have and to recruit talented attorneys for our open and future positions. The best way to do that is obviously through the enhancement of compensation. In our recent budget request, we have asked the General Assembly to consider 3 to 7% percentage increases in staff compensation each year for the next 3 to 5 years in an effort to combat the inflation we have all experienced. Since 2019, our turnover among attorneys and professional staff is nearly 83%. Court staff turnover is just over 88%. Again, our total staff turnover since 2019 is well over 80%. When hiring, we prefer attorney candidates with 5 or more years of experience who can make an immediate contribution to the court. Recruiting from private practice and other public positions has become increasingly difficult, and retaining experienced staff attorneys even harder. Without competitive compensation, we risk losing colleagues who understand our procedures, our caseload, and our high standards. After 8 years, without any turnover in my own chambers, I lost two very experienced staff attorneys to the private sector within a couple of months of each other. Together, they represented over 40 years of institutional knowledge that cannot be easily replaced. Both felt that working on our court was what they were meant to do, but they could not overlook the substantial increase in pay. One told me that it would have taken a small fraction of the increase in pay she received in private practice for her to have stayed on our court. As for judicial compensation, under House Bill 86, I once again thank the General Assembly and this committee specifically for passing HB 86, which fundamentally changed judicial compensation in Georgia. The bill sets a ceiling on our pay at 99% of what federal district court judges in the Northern District of Georgia were paid roughly 3 years earlier. Federal pay is adjusted by an inflationary index, so the ceiling is predictable. It is my hope that in the years when Georgia is not experiencing unusual financial tightening, the General Assembly will increase, if not fully fund, judicial compensation. Doing so will go a long way to retaining our talented and experienced jurists. Our court is experiencing the normal increase in caseload you'd expect in a growing state like Georgia. We are well above our pre-COVID numbers, which had been our lifetime peak. Total cases rose from 3,120 in the 2025 terms to 3,638 in the 2026 terms, and over 16% increase in a year's time. Applications rose over 20% in the same period. This sustained growth continues to place significant demands on our court and our staff. Finally, a recent matter of particular importance is the possibility of the Supreme Court unilaterally transferring jurisdiction over most of the murder cases to the Court of Appeals. I am not for this transfer, especially under our present circumstances. Most of the judges on the Court of Appeals share this view. All agree that it would require significant resources and planning to handle appropriately. I have never heard of an appellate practitioner express support in moving these cases to our court, with the exception of the Attorney General's office in the Hart versus the State of Georgia case. Hart v. State, decided by the Supreme Court in June of last year, makes clear there is no immediate need for such a transfer, and that transfer would be discretionary. As the Supreme Court itself acknowledged, non-capital murder appeals make up a large percentage of its caseload. Moving that volume of work would create an unfunded mandate on this court, already working at or above its present capacity. We are certainly able to absorb this new jurisdiction, but the burden is not minor. The necessary resources would be significant, whether that be a substantial increase in support staff across our court or a new 3-judge panel phased in over 2 years, along with all necessary build-out and support resources. In 2016, coordinated action by all 3 branches of government expanded the Court of Appeals by 3 judges, the Supreme Court by 2 justices, and transferred a significant portion of the Supreme Court's civil jurisdiction to our court. It also funded a building we occupy today. The Nathan Deal Judicial Center was designed to serve Georgia's appellate courts for possibly the next 100 years. That process remains the most successful modern effort to strengthen and to adjust to the needs of our appellate courts. We have reached out to the Chief Justice and others on the Supreme Court and requested that any announcement be held so we can begin a 2016-style global discussion. It appears a majority of the Supreme Court may be prepared to move forward with the announcement to transfer jurisdiction without that broader discussion with existing and incoming leadership of the other branches and prior to securing the necessary resources. That approach would certainly conflict with the 2016 global agreement under which murder jurisdiction remained with the Supreme Court. It is still my hope we can use the same model to discuss not only the potential transfer, but also the staffing, compensation, and caseload growth and reach a true consensus in the allocation of resources. Any transfer would require millions of dollars in new funding over the next 2 years. We are grateful for the General Assembly's past support and look forward to continued collaboration. The Court of Appeals exists to serve the people of Georgia through fair, timely, and principled appellate review. We welcome the dialogue with this committee. Thank you again to our hosts at the University of North Georgia and to the members of the Judiciary Committee. I am now happy to answer any easy questions or to assign the hard ones to much smarter people among us.
Mr. Chairman, I've had somebody text me that can't get on the Zoom. What do we need to do about fixing to get on Zoom?
That was well planned.
Let's see.
Transfer, it's on the website for the legislative house. I can, it's not a.
Email me. About
If you just want to watch the meeting, go to who wants to participate, have them email me, matt.reeves@house.ga.gov, and I will work with Summer Little to get them hooked up.
Oh, yeah.
Yeah.
He actually wants to.
Yes. Matt.Reeves@.
house.ga.gov.
Okay. Or does anybody on the committee have any questions? Representative Oliver? You need to hit your button one more time there. There, now you're on.
Thank you for the invitation to come today to this lovely spot. I appreciate it. I am asking my smarter member here for specifics about when we statutorily changed the jurisdiction between the Supreme Court and the Court of Appeals. It was not that long ago, but was in some recent time frame. And one of the reasons I ask about that is that what analysis do you think we planned when we changed that jurisdiction? What analysis do we have that might be available to us today that would analyze what that change of jurisdiction did? And Mr. Chairman, the other jurisdiction change that we did this year, which we'll not talk about today, but which is on my mind as a parallel, we changed the jurisdiction of the magistrate court that probably affects more Georgians. What analysis did we do when we changed that jurisdiction that's going to come back in a year or two for us to make adjustments for?
It's, I came in 2018. I've talked to several people who were heavily involved in 2016. And honestly, the results thereof make perfect sense. Basically, domestic cases, equity cases, wills and trusts became part of us. And that was originally the original jurisdiction of the Supreme Court prior to 2016. Right. But it's my understanding that it was years of a significant amount of studies went into it. You know, this is before the Nathan Deal Judicial Center, but years of study went into exactly transferring jurisdiction to us. And there were people in the Supreme Court then, my understanding, that wanted to transfer murder at the same time. But ultimately what was decided was that civil, equity, domestic would be transferred to us. We would get the benefit of a new panel of 3. And in fact, our Chief Justice now was one of the original members of that panel of 3. And they would get 2 more. They felt like that they would be able to issue more writ or cert by doing so, and it would open us up for the jurisdiction. And since then, I'll say that particular transfer made perfect sense to me.
And it was planned, is what you're saying. There was an analysis.
It was studied, and it's my understanding, again, I've talked to people who were very involved, that they started discussion and started bringing in everyone and then went to existing leadership. So everybody was on board, not just on the transfer, because it was very costly, especially with the new building, but everybody was on board with the agreement. And that agreement ultimately left non-capital murder jurisdiction with the Supreme Court. Now in fact, we have somebody that was heavily involved, and I apologize. PJ Doyle was heavily involved in the process.
Yeah, I was one of the people on the committee back then, so it was a lengthy process. Discussions like this have been going on since the 70s. And I have a bunch of reports over the years from, the analysis and the push. It wasn't until 2016 that all the parties could come together and come to an agreement about making that jurisdictional transfer, primarily from the Court of Appeals perspective, because we were acknowledged that we were going to need a bunch of resources and a lot more people to handle this, which we were afforded and we got. And so that made it doable.
Yes, sir. Thank you.
Representative Evans.
The right way.
Got a
There
master
for now
hand.
it's live. Thank you so much to everybody. I think when Vice Chair Reeves and I were talking about doing this, I don't think we imagined that there would be as much interest. So we really appreciate it. And maybe we were right that this was a conversation that needed to be had. So it's always good to feel right, at least for a little bit. I have a couple of categories of questions. The first is staff pay and resources. And you mentioned, and I think it was very smart of us to tie judicial pay to something that's indexed. And so I'm glad we did that with the judges.
Absolutely.
Do you know if there's anything like that at the federal level that exists for federal clerks, federal staff attorneys, court staff at the federal level that we could potentially consider tying to?
It is my understanding that, especially among senior, that there is, but I don't know the actual facts of that.
And that's something we could pull. It just occurred to me when you were talking.
Certainly.
We have to,
Do we have it from federal?
we could have at least what the salary ranges are at the federal level within the.
But specifically, were you asking about an amount or just the process by which they got consistent increases in compensation?
Yeah, I'm curious in the amount so I think it would be good for us to hear as a committee how far off we may be. But then I would be interested in knowing if that's already indexed, then we could just tie it, maybe we could consider at least tying in a way that we don't have to come back and do this again once it's indexed and it's
The
indexed.
notes I have is the starting salary with us is just over 98,000. And an L4, which represents 11 to 17 years, would be around 138. On the 11th Circuit, it says the developmental starting salary is in the range of 90 to 112,000. But around 3 years of experience, it goes to 112 to 146,000. And then once you get to the 5 to 10 years of experience in supervisory, you would be anywhere from 106 to 197.
A significant difference for sure.
If I may, Mr. Chairman, please keep in mind that the elbow clerks, as they call them in the federal system, are right out of law school normally or recently out of law school, short-term positions. These are career positions on the Court of Appeals. The 11th Circuit has a central staff that they're not term limited, and I'm not sure what the situation is with respect to those positions.
Okay, that's good. And then my other question related to staffing is just how many staff attorneys each judge has? Are there any term clerks? Thoughts on term clerks? What kind of central staff numbers do we have? Are there thoughts on whether do we need to create more positions? Would that be us or would that be y'all? Well, I guess it would be us because we got to pay for them. You can create all you want. They just might not get paid. So how many do we have and how many do you think we would need? And then what kind of use of interns is going on? So that's a loaded question, but I just really want to hear about staff.
Well, I will say part of the process was exploring that the way I understood it back in 2016 as well. And ultimately it landed on what was the existing model that we have today. One judge has 3 staff attorneys and assistant per chambers. One of the options we've discussed in the event we did inherit murder jurisdiction would be adding another staff attorney, but that would be outside of our model. It would require a substantial build out. And one of the concerns that we had at the previous was that at the previous setup, the previous building we were in, where in some cases, a lot of our staff attorneys were throughout the building. When I first came, I had 1 staff attorney in my office and 1 in a broom closet and 1 that shared another office elsewhere in the building. And one of the things that we wanted was all the chambers to be alike. similarly situated, but built on a model of 1 + 3 staff attorneys, as I understand it. There's been some discussion about term clerks. It's not necessarily where the direction that I would want to go. Because you're constantly training folks, as opposed to, I feel like the Court of Appeals in the state of Georgia is meant to get the job done. And we've got excellent people working with us, and we're constantly in the process of doing it. And even with our new people, with the turnover we've had, we're constantly training. Otherwise, the way I understand it, even if we bring in someone with 5+ years of experience, it usually takes them 2 to 5 years to really get their legs up under them to where they're comfortable with what we do. And some actually have like their number one or main law clerk in their office, staff attorney in their office. And usually before somebody's comfortable with that position, it's 5 to 10 years before they really get there.
Yeah, Yeah, I'm ready. That's one of the things I wanted to kind of point out. I also lost a very senior staff attorney to the private sector a couple of years ago. It took me over 8 months to find someone who was even remotely qualified to do the job. And he was an attorney who had about 11 years experience, some civil, some criminal. I hired him out of the Fulton County DA's office. He was in the appellate division there. And he has now been with me going on 2 years. He's just now sort of hitting his stride in being able to get the cases timely moving. And that affects the other 2 people in the office. And so it's a senior level job, at least, to come in, and then it takes them a while to get used to doing the job. So a term clerk situation, if we were going to get murder, I'm not sure that you're going to want a first-year lawyer who's handling these really serious, if that's going to be what they're going to do or how that would work. I think it would be a tough one.
And then what kind of use of central staff and interns, if you can talk to me about that.
We have 15, right now we have 13, but that's because Chambers stole a couple. Normally we have 15 central staff.
Okay.
And this is Chris Smith, our clerk.
Hi.
I could spit those numbers out. We normally have a sector of those central staff attorneys who review everything that comes in. First, the directs for jurisdiction, because you can knock out 20% of what comes in right there and save Chambers time. They also look at all applications first time. And as y'all know, the discretionary applications, that's the only chance somebody has to make their case for why they should get an appeal in the first place. So our central staff attorneys look at applications, do a deep dive into it. And if they don't know the process, then they probably will have a hard time filling in the gaps, because all they have is what the appellant or applicant has submitted. They don't have a full record. And then there are interlocutories, and y'all understand might be something really important that can save everybody else a lot of time, that a trial judge said, okay, I'll certify this as worthy of immediate review. And that's 8 to 10 people doing that full time when we are fully staffed. We've been staffing in empty chambers for a while now, and you can't really hire a permanent lawyer to work for a judge who's not there yet. So those positions have been filled by our central staff. If somebody gets sick in chambers, maternity leave, those kind of things, central staff we hire people who can drop into chambers and pick that up, as Judge Doyle pointed out. You really have to hit the ground running to keep things moving. So central staff is really an engine of work and really important. We're looking now, by the way, for a couple of lawyers and 2 more for chambers now that Judge Epps is kind of appointed.
To answer your question about interns, when I was in law school, which was a really long time ago, almost as long as ago as Stan Gunner, the idea of an intern, you got paid something to help during the summer. But we don't pay, and nobody apparently pays, at least in the government world. This past summer, I had 3 staff attorneys, 3 interns along that was sort of supervised by 3 staff attorneys. We did more for them, frankly, than they did for us. We are trying to help them in their mentorship / educational career much more so than they're not able to take a case and do anything with it. They could do some analysis, they could do some basic research, but there was no movement of cases that was made better because the interns were there.
Sure.
It was really the other way around. We hope to make their experience a little better.
And I would,
To add staff or panels.
Correct me if I'm wrong, but it's my understanding that when the building was built, it was anticipating starting out with 15 Court of Appeals judges. Then there was space for maybe up to 24. But since then, as you know, statewide business court took over a large chunk that required pretty substantial build out courtroom, office space. That took up a large chunk. It's still my understanding, and we actually need storage space as well.
Yeah.
But it's our understanding that we still have maybe the space for.
Yeah, that's all. The business court took out the backside of third floor, which was, I think, was at 6 judges, 2 chambers.
Yeah.
Whatever, 6, 2 sets of 3, sorry, and then we're left with 4.
But it would take up a good portion of what we have left.
Okay.
And I imagine the build out's going to be substantial.
Right. Right.
As
Okay.
well. And also going back, it's our anticipation if we were to absorb murder jurisdiction that the clerk's office would at least need
We need another document.
at least one, and we probably need another central staff position or 2 on top of the openings we already have. And on top of, if it were to be the model that I'm not necessarily for, 1 new staff attorney per judge that's there now, that's 15 new positions.
Mm-hmm.
And if you did a panel, just a new panel of 3 judges, that'd be 9 new staff attorneys that we would need to fill that out.
and
And
don't hold me to this exact number, and Sarah, maybe you'll recall, but from what I can glean, I believe that murder jurisdiction would bring greater caseload than the shift in 2016, just by a little bit, not a ton, but more. But I think that's interesting perspective, that just the different process for each, and going hand in hand with looking at what the greater resources are for the appellate system as a whole.
Related to the staff and the interns less so, I mean, I totally understand, but they're there, everybody's involved. It sounds like, I mean, y'all are still, each judge is only one person. I know you make the decisions, but you have reliance on your staff attorneys, and I'm sure the interns are involved with more and more folks moving among jobs, perhaps before they get to you, or even if they're coming from law school. We've got, I mean, our law schools, all the law schools in Georgia have done a great job of establishing clinics. And so some of these folks are coming with experience. And it occurred to me as we were talking about all this, what kind of system is in place to ensure that, I mean, y'all know when you have a conflict, but how do you make sure that staff attorneys and interns that are involved in discussions are checking their conflicts at the door as well?
It's a good question. I've never had that concern specifically.
I've never had the concern, but it is something that I would talk about with each staff attorney, and also with any interns that we might have, is, please, before you would look at any file or anything, be entrusted with any file, first looked to ensure that all the attorneys, the judges, and everyone, that you don't have a conflict. And we, we ourselves, we have a system for the judges, at least, that we can plug into an electronic system, have standing conflicts, temporary or permanently, dated or what have you, that we can plug in, and the system will skip over us. So we have that. And then I, as a matter of practice, every time I look at a case, I also look at it anew to just be sure something hasn't changed that perhaps I forgot to place into the automatic conflict. So it's, I think it's an issue of training and just having to stay on top of it.
Yeah, and the judges are less of a concern, but if you're talking about newer or younger lawyers, do they know, is there a system in place so that they know how to check if they have a conflict? I mean,
It's
If you've been
about
at it for a while,
talking-
you might know, but
It's about talking to my staff attorney, Charles Bonner. His mother was Alice Bonner, Fulton County, and my other staff attorney worked in the business court with her. So when we all started, there was a discussion about, okay, well, probably shouldn't take any of her cases that come up if she's the judge that was on the case. They didn't feel comfortable ruling against their mother kind of thing.
Right.
So, but it's about that every time. Like, so the same thing when the guy came from Fulton County, we had to make sure he was primarily working on just one case, which made it simple for us when it came to, recusing from anything that he might have touched. And it's just making sure that our clerk's office is aware of it. And
It can
that
be
the judge
very
is aware of
tricky.
it.
You know, when I was still at the court, you bring up a great point, which is we would have in pretty frequent discussions where a staff attorney would say, hey, I just noticed this person's the attorney. We had this, but what's really interesting is sometimes even for the judges, you've got a record that's thousands of pages. You will be halfway into a case, someone who's not currently an attorney, but someone who's a witness that's buried in the record, and you find it out halfway through the case. It's amazing how many times those kind of things are buried in the record and we don't even know it until you get so deep in. And it's very, very hard. You know, the Supreme Court, I think, has adopted a system where you have to certify interested parties that they get to review and then figure out. We have not done that because you just haven't. I'm not a judge anymore. My God. I've been gone a week and I'm still saying week. We did not do that, but it's a great question because I do want the public to know a lot of times whenever we stumble onto those things, all of my former colleagues and I, you work really hard to catch them, but it is amazing sometimes. I got into one case where a previous lawyer who was at trial, I didn't need to be on that case, but you don't find that out until months in.
All right, Representative Reeves.
Thank you, Chairman. Question for you in a minute, Chief Judge Brown, but in addition to commending UNG, I noticed we got our local elected officials here, Senator Gooch, Representatives Wade, and Representative-elect Dockery. Appreciate y'all coming. And then in the audience here, it is so encouraging to see such cross-section practitioners at the appellate level, trial judges, municipal court judges, state bar. We have a great number of prosecutors. Thank you all for coming today, and we look forward to hearing from y'all in addition to judges. Two questions that have come to mind. Appreciate that detailed presentation. Sure. The first is when I looked at other states that are about the same size as Georgia, Virginia, Ohio, North Carolina, Arizona. Didn't look at Florida and Texas because they're 2 or 3 times the size. And I know they do district courts, which is, that'd be a big change. But these other states that are about our population seem to have a lot more Court of Appeals judges than we do. And I know it took a long time to go from 12 judges to 15, but the state's about doubled in population in 25 years or so. And we've only added 3 judges in longer than that period of time. Is 15 enough? Do you think it's time to do another panel of 3? And would that be enough?
I think that we're looking over the horizon that it's going to be absolutely necessary. I told you the growth of 16% and then 20% in applications alone. So just with the growth in the state of Georgia, without any transfer of jurisdiction, it's very likely 4 to 6 years that we would need a new panel without a doubt, probably sooner than that. But definitely if we had the new jurisdiction, that would be absolutely appropriate to look into that, the possible 3, instead of, if it was a 4-year based on natural growth, maybe with the new jurisdiction over a two session period, maybe funding, because it's my understanding that if the Supreme Court were to make an announcement through opinion or otherwise that they're going to give us murder jurisdiction, there would be a sunset of around July of next year. So there'd be a period of time, there'd be only 1 session. So it could very well be that we bring in staff attorneys to begin the process of starting a new panel that would handle the murder cases. In essence, that would become what they would do in answer to the existing judges, and then build out would be concerned in getting money set aside for that, because we don't have the space really for any new people in the present circumstance. And then if we went with that model, maybe in the second session, we'd finish that up. Of course, I think that would take a global discussion, not unlike 2016, to get it done.
And that brings up a point. Representative Evans, who got this started, and Chairman Gunner, they're on Judiciary Appropriations. We've let all the people on that subcommittee know about this meeting. Some of them are watching, some of them are here. And so I know, there are financial issues in addition to policy, but
And I've
definitely.
had a couple of conversations with Chairman Gullett as well.
Good. But, I look at these other similarly sized states and they seem to have a lot more intermediate appellate judges and we've had a lot of growth. The second thing is the Speaker of the House, I love his saying that let the data and the facts drive the policy.
Certainly.
And I see you brought a lot. I've got to talk to the clerk a little bit earlier. I know y'all have a lot of data. Drill down on that 16% and 20% growth and things where you see that are sort of proliferating. See if you could pinpoint some of that growth. And if there are procedural or statutory things that can tune up, some things that I hear emergency motions or so-called emergency motions are one thing that are, the bane of your existence that are proliferating. If there's any way to tune it up to where some things like that may stay at the trial court level, or that there's a way other than a three judge panel handling, things like that. If there's anything we could do to tune up some of the jurisdiction procedure and things like that, I think that it may help. But I think that goes back to the volume, where is this new growth coming from? And are there any changes that could be made to deal with that growth? Do y'all need to be hearing it versus, keeping something at the trial court level?
I was looking towards my PJ, who actually literally wrote the book.
Mr. Vice Chairman, I put out a chart here that details the resources of the three states ahead of us in population and three immediately behind us in population. If I'd gone out a little further, I believe New York is number 4. They have 83 appellate justices, so titled. And one thing I know from talking to New Yorkers is that the difference is that New York is kind of wide open in terms of interlocutory appeals. From the conversations I've had, I don't know how they get anything finalized. When I look at a discretionary an interlocutory application, really the main area in which I focus discretionary judgment as opposed to is this right or wrong on the merits, is this worth adding a year to the life of the case? Because Georgia is pretty rigid or limited with respect to the interlocutory appeals that are permitted, that I think is one of the reasons that you've already done that keeps our jurisdiction pretty much in line. Can't think of anything that I would recommend to shut the courthouse door to a larger set of cases.
I won't talk about it too much since Chairman Leverett isn't here, but he worked a lot on petition for review, and y'all's 5-6-35 discretionary list of appeals like workers' comp and things like that. It seems to me that the petition for review, those are more direct when they are appeals of appeals in a lot of cases. And so that might be something to look at to see, are there some kinds of petition for review that ought to go in 5-6-35?
Petitions for review are to the primarily the Superior Court.
And then appealing
and
that.
They come up to us by application.
But should they all be direct? Because I think the way that is written, there's an argument that they're all coming by direct. And I think some of those, if you look at them in substance, they look an awful lot like your discretionary list. And I don't know that anybody's ever looked at that, but that might be something that could, if y'all are getting a lot of petition for review cases, one way to do it might be update 5-6-35's list of, those long lists of things that are there by discretionary appeal, because they're really appeals of appeals.
Yeah, and I think because they're appeals of appeals, I don't know what the argument would be. I'm sorry.
Good. You're on.
Yeah, I was good.
You need to be closer though.
I don't know what the argument would be to say that an appeal of an appeal by way of a petition for review does not fall under 5-6-35A. I think it does.
Right.
We do have the rule in other contexts where, okay, it looks like you got a direct appeal, but it's not a final judgment, so it's interlocutory and so forth. It comes up in domestic cases where it's a close call whether it's direct or discretionary. So I am doubtful, and I'm not aware of the existence of other sets of cases where the law needs to be adjusted to make more things discretionary.
Okay.
I'll keep an eye out for it.
And I think some of the numbers are driven by pro se applicant, self-represented people, AI. You were laughing about emergency motion, somebody's bent your ear.
Quote unquote.
Well, for the first few months of this year, whoever handled emergency motions that judge was slammed with every day an emergency motion that was actually a mandamus from somebody who wanted the trial court to do something. It's not something that we would handle. So what we did was build a back end so that those are now docketed basically as directs. They're original petitions. We have a whole new letter for the first time since I've been here. And we tried to sort of spread the load out on those. That's one way we tried to manage it. The increase in applications has truly caused a strain, and I can go back and look at what I have to see what the are, but divorce seems to be one of the things that we do see more. That's our jurisdiction now. Beverly Cohen knows this. That's all I do. I don't know that policy wise, whether those should be directs, whether that would help or not. I don't know. That's.
And y'all went from 12 to 15 when you got more domestic jurisdiction, right?
That's right.
Okay. 10 years ago.
10 years ago.
Okay. All right. When you bring up the emergency motion onslaught, one of those states similar size to Georgia also keeps on the senior Court of Appeals judges, kind of like the federal system. And so when I hear about that, if it's a motion rather than a review of a whole case, maybe having the ability to have senior judges or somebody other than a 3-judge panel or the whole court hearing those.
Do other states have, I know that the Court of Appeals here in Georgia in the past has looked at splitting jurisdiction with civil and criminal.
Mm-hmm.
And I don't think that worked out or it never got started. But do any of the other states do something like that?
I'm gonna look to my PJ. Texas absolutely does. Does Florida?
No.
Alabama, does Alabama separate it out?
It's on here.
Oh, it's on there.
Alabama and Tennessee. Alabama and Tennessee have 2 intermediate appellate courts, civil and criminal. Pennsylvania also has 2 intermediate appellate courts. They have a Commonwealth Court and a Superior Court, just to be confusing. Mm-hmm. And the Commonwealth Court handles appeals involving government entities at the appellate and trial level. Oklahoma's only intermediate appellate court is criminal, and their chief judge, by the way, is named Lumpkin, coincidentally. Texas has 2 courts of last resort, a Supreme Court and a Court of Criminal Appeals. I would urge you not to divide us up by jurisdiction. As a practical matter, in my experience, the criminal appeals, for the most part, are less difficult. And so there's an imbalance there. And I also think that there is a lot of the law is the law, criminal and civil. Some of it is different. But I would hate to see the law subtly diverging between criminal and civil cases where legislation does not provide for such divergence.
It's like you have criminal and civil that both deal with the rules of evidence.
Just so.
Yeah, that kind of, okay.
I came from a middle Georgia trial bench where all judges did everything. And so it seems more natural to come to our court. I couldn't imagine what it would look like. I'm sure obviously people have done it with success, but the present model, the way we work, where everything comes to everybody's office, and so we're all experienced in all type of cases, seems to be working.
Well, if we have an expansion in the number of judges, we do have an old legislative office building that has plenty of room in it.
Talk about room space.
Yeah. Or we can kick the business court out and expand it that way too.
That's a thought.
I don't want to talk about their caseload in comparison to y'all's. We'll save that for another meeting.
I have
Representative Evans.
Thank you, Mr. Chairman. One of the reasons that I started talking to Vice Chair Reeves about getting this conversation is that just as a practitioner and anecdotally talking to other practitioners, when you look at this and you look at the size of the court, it really seems obvious to me that we need another panel, maybe more than one other panel. And I know that costs money and we can't snap our fingers, but one of the things that I know would be helpful, if the judges on the court agree, that it would be nice to have some help. And then for those that feel like I do, it would make our lobbying efforts among our colleagues a lot easier to have some data. And I'm going to tell you what I'm talking about. I think if we, to most folks, they would say, well, they're getting the job done. They're issuing opinions within the 2 terms. Everything is working. So why do we need more judges? But I think that I think there could be a picture painted that says, yes, you are, but wow, it looks a little scary. You've got a lot of opinions coming out on the last day of term. Anecdotally, when I flip through if I put in a date range on the website and I see the opinions come out, it's a lot higher at the end. And not that you can't do great work under pressure, but we all know that that's probably not the best, and the public would probably be better served to not see that rush up to the end. I also know if you look anecdotally at Westlaw and you do a search for concurring judgment only, you are almost exclusively going to see that on distress or within a couple of weeks. And those are opinions that affect people's lives. And I'm not sure that that's the best feeling for the public, certainly not the best feeling for a practitioner to get an opinion on the last day that has one or more judges concurring in the judgment only. And so while the job's getting done, is it getting done in the best way that it can or that y'all would like to do? And I say this not as a criticism, but as a, how do we help you do the best job that you want to do, but perhaps the 2-term rule rushes you. So I think, do we need changes to the 2-term rule? I think the 2-term rule is great for timeliness. And if we're going to keep it though, I think we need more panels. And so I wanted to see if it would be possible, whether it's something that's reported on the website or whether it's just something that we could have on a periodic basis so that we could share with our colleagues when trying to advocate for this, case opinion counts by week and by panel. So we can see how are these things actually coming out? And how do we make those more uniform? That what I was saying about concurring in the judgment only, this is anecdotal, me looking at Westlaw, but that can be reported. That could be shown somewhere on a website so that there's transparency to the public so that we have help advocating for you. And then also, y'all know, and you can hold yourselves accountable. And then the other thing I was curious on data wise is how often Rule 36 is used, and that being where you can affirm without opinion. Because again, the job is getting done and y'all are doing an enormous amount of work that I wonder how you do it, especially when you look at these other states. And so I think some transparency for us to utilize and for the public to see, at least on those 3 areas, I wonder if that could be something that could be done and reported out.
Absolutely. I mean, I agree with everything you've said. It's absolutely reasonable. I'll start with Rule 36 because I get it a lot from people that practice. It was unusual even when I came from the trial bench in personal practice, where you have a Rule 36 where you don't actually issue an opinion. Now, we all don't do the exact same things within our chambers, but I will tell you, if I issue a Rule 36, as much work went into that opinion as any other opinion. In fact, for the most part, before we even get to the discussion of a Rule 36, the opinion itself is already drafted. And if it ultimately decided that we're not going to publish this, and in fact, it's a Rule 36, if it fits in to what we allow for Rule 36s, then that's when the discussion, so that 27-page opinion that's already prepared and absolutely adequate to go out might, just through discussions for whatever reason, the cliche of bad facts leading to bad law or otherwise. And I've actually seen, even when I was on the trial bench with listservs or otherwise, especially with people who specialize in a specific type of law, I had unpublished opinions used in my court quite often because they would share these cases among themselves. So that would actually go into the consideration of whether or not you're even going to send something out as unpublished. So I understand the concern. It's a reasonable concern, and I've had this conversation, and I'm sure every time we have a panel at conferences, somebody's going to bring up Rule 36 is you just don't want to do the work. But I'll say for my office, and I believe for most offices, as much work goes into what ultimately results in Rule 36 as any other case, because I'm still sending a memo to convince other intelligent judges that I'm doing the right thing.
I was gonna say, it may not be quite as pretty as an opinion. That's the biggest thing, but it's still gonna be 15 pages long that we're circulating behind the scenes. It's just, I think when it comes to that, we're deciding, this is maybe a convoluted issue. The trial court really, the outcome is correct. There's nothing we can say that's gonna add to the law of Georgia. We're probably just gonna detract from it. And so those are kind of reasons you might get a Rule 36. I think it's a frustrating situation. But back to kind of your at the end of the term, a lot of things come out at the end that seem to be the harder. At the beginning of the term, you're going to see a single enumeration of error, criminal case, motion to suppress drugs in a car. The guy said, yes, you can consent to search. Pretty straightforward what the law is. Those things are going to be pushing out earlier on. And that's, your staff attorneys. So there's, how they work too. And then one will say, I want to do a criminal because that's a little bit quicker and simpler. And then I'll pick up the big civil. But the civil might take 2 months for them to draft. It's not something that they're sitting down in a week and doing because it's pretty complicated. It might come out on the last day, but it doesn't mean we started the day before working on that matter or the week before. It might be in the pipeline, but because the nature of it or what we think is important, it's one that we think about longer. So there's a lot of things that go on. Now, the JOs, I do agree, you're going to see those more. And I think that's a nature of maybe internally, we have too much pressure at the end, and another panel or some more assistance throughout the term would be helpful to giving us a little more time on some things that we all want to think about a little longer. So
Or even I think the transparency will help, because I think that will help. That'll be the easiest way for us to make a case to add more resources. And then maybe it also influences and lightens some internal procedure that could change. I don't know. That's way above my pay grade. But just lost what I was going to say. I'm so sorry. I'll figure it out later and come back. But I do think just having that information available, whatever the reason, having it available, because over time you'll see a trend. It'll probably make sense. But I do think that the transparency of that would be very helpful, including Rule 36. Oh, did I mute myself? Sorry.
Yeah.
Well,
You got to repeat all that.
oh gosh, no. I don't have to repeat that. I forgot what I was going to say, but I think that the transparency, regardless of the reasons, I would just, I know the committee, I would request it for the committee, but I think it would be nice for the public and practitioners to be able to see that too.
And a lot of that is created by the two-term rule, the fact that you've gotten through a term and there's actually drop dead dates as you go along. So of course you're getting wrapped up in some cases on your next term's cases. So it pushes towards the end. There's negotiation, there's discussion back and forth between judges during the process of the term. I mean, Chris would do better. Somebody else, how unusual is the two-term rule?
The two-term rule, as far as I can tell, is absolutely unique, but other jurisdictions have other deadlines. So I'm aware of judges who get their pay docked or even get it reported to the disciplinary body for being late. So
See, well, I think the transparency is a baseline, but then what I was thinking of that I had forgotten for a second is, do we need to consider a safety valve, an exit off the two-term rule in certain situations? Because I think practitioners would rather have a well-reasoned, either two with a dissent or a better opinion than a couple people that are just sure, fine. On the last day. So sometimes you might want to hatch, is what I'm saying, a parachute out.
There's a lot of pressure created. I personally like the two-term, keeps things moving. I absolutely understand what you're talking about. And there are circumstances, especially when you come down to the end of term, where we've discussed exactly what you're talking about. How do we expand, have those circumstances where this particular case because it might go whole court towards the end of a term. Maybe it would be nice if we had options. I don't know how drastic those would need to be, but I personally like the 2-term rule.
My understanding of
Forces us to get stuff done.
I'm sorry.
No, you go ahead.
My understanding of the law is that the Supreme Court can extend its term and we can't. I'd also point out that legislation calls upon us to expedite incarcerated criminal cases and custody cases, which tend to be, as Judge Doyle indicated, less substantial, less weighty in terms of complexity.
You got one? Okay.
I've got one.
Representative Reeves.
Chief Judge Brown or any member of the board, I know the 11th Circuit has an alternative dispute resolution office, and they require it in a lot of cases. There are various courts in Georgia that require it. I'm thinking through state government. I don't know that many of the administrative hearings or anything, I don't think we have much ADR that's offered or required throughout, appellate or other litigation at the state level. And ADR is relatively new. It came along in the 80s and 90s, and in my experience, it works. It lets people get stuff off their chest and, have their day in court and get a lot of attention and have the energy there and get decisions made on their case. Is that something y'all have looked at maybe finding a way to get ADR in appellate cases to make the lawyers and parties sit down and think about the case before y'all have to sit down and think about the case?
So
it doesn't happen in every trial court.
I have the statute sitting in my office, I think, that allows us to have a process through which, and I'm not sure if they've ever done it in the past. Chris says they did, so he can talk to it. But I know that as I'm getting to be an older judge and the horizon of retirement gets closer, he's looking at me like, what's closer for me than you? But we're heading that direction. The idea of being maybe a senior judge that was referred cases that maybe could be mediated like they do at the 11th Circuit to try to get things resolved or moved out of the way may not be a bad idea. I think it's the timing with our briefs. You get docketed, you got 20 days. It's a very quick process. So sort of thinking through that, maybe it would be, and this is more, but the notice of appeals way back in the court of, down in the trial court, maybe we would get some notice of it and start a mediation process while you're waiting for your, records to get compiled and your transcripts to get compiled. There might be some way to do it, but that may be an interesting.
Yeah, I remember hearing Judge Botifer in Cobb County say one time that he's not going to require citizens to come on jury duty and spend their week in a trial if the parties haven't sat down, both lawyers, both parties, and talked through the case. And so it seems to work a lot. And the off-ramp Representative Evans mentioned, that if the parties are saying, no, we don't want to mediate, that might give y'all some extra time to look at the case. If they want to go ahead and stay on schedule on the briefs and the decision and all that, then go ahead and mediate it, because a lot of those can end up working yourself out of a job where the parties, take charge and get the case settled.
Mr. Vice Chair, having recently been on the Superior Court bench, I will tell you that as former president of that council, Superior Court judges, that ADR was not everywhere, but I would say it was prevalent among judges of the Superior Court that they would refer cases to ADR, especially cases that were probably not criminal. Not all criminal cases are amenable to that process, but particularly civil cases. The one thing I would point out, after you've tried the case or you've gotten a significant ruling, the dynamics of the case have changed. So what your position was at ADR pre-trial may be dramatically different post-trial, pending appeal. And if there's not a mechanism sort of baked into the process to invite you to that party, it may be hard for you to see how to get back to ADR once you realize I have this problem that I didn't have before, or I had this advantage that I didn't have before. So,
yeah, if I may, I can report having practiced when the Court of Appeals had an ADR program. It didn't work. The 11th Circuit's program worked. The difference is that the 11th Circuit lets you request it anonymously. What I would do, I was building my appellate practice at this time, and meaning I was usually representing people who had lost. And so I would say, sure, yeah, fill out the ADR form, and the appellee would always respond, we don't want to do ADR. They're lucky we're not seeking sanctions. So it failed, in my view, for that reason. And everything we've heard suggests maybe it's worth a try again.
Doing family law, a lot of cases, once you file a notice of appeal, stuff still goes on because life goes on. In a personal injury case, there's no familial relationships going on for the most part. And I think the mediation would be something good in family law cases, maybe as soon as you file the notice of appeal or a motion for new trial. Because often unfortunately, I have to file motions for new trial, not because I'm looking for a new trial, but because I can't get the transcript in time to get the discretionary application, the transcript for the file discretionary application. And so much stuff keeps going on, and we got to end it. And I see all these cases that are dismissed because they did not file a discretionary application. Those are mostly pro se, and I think that's a big problem too, because the pro se don't know about it. But I think that's something that needs to be worked out through the legislature, where they require some sort of mediation. And I got one case now where my client kept telling me he begged his trial attorney to go to mediation, and they never did. And this was Cobb County. And Cobb County has mandatory mediation. I don't know how it got missed.
All right, you got to carry that bill. Representative Oliver.
I support a new discussion about mediation, and particularly in relation to the pro se, which I have experience with. I don't know whether the statistic that 56% of cases are still resolved in mediation favorably. I don't know whether that's still relevant or not, but even if you had a much smaller in a different setting, I think it would be something that we very much should consider. I also want to support Representative Evans' discussion about transparency and data. This is the first time in my political career where the lieutenant governor, the governor, and the speaker have not been practicing lawyers. And the drop of lawyers who are practicing in the General Assembly, I don't know what's going to happen in this election, whether that will change, of course, but it's a different dynamic when you don't have one of the three folks in that office to be somebody who's gone to court a lot. Question, if the Supreme Court were here today, would they be telling us that their caseload, even though we reduce their jurisdiction, has grown? I'm curious what they would say. But not in I'm interested in that data as we look at your data issue, which is important to look at. This is very helpful. What is the Supreme Court going to say? And I'm going to go back again, Mr. Chairman, we're going to hear something about this magistrate court change.
Okay.
My understanding is there's growth, but not compared. I mean,
That would be my guess.
I've had conversations, but I wouldn't say we've had all the conversations, but nobody has led me to believe this is something that needed to happen because they've expanded. I think that would be even a greater reason for what I keep calling a 2016 model, where prior to doing anything abrupt, we had a reasoned, thorough conversation, studies or otherwise, transparency and numbers or otherwise, what each of us need. What are they not? What space does that give them? And what additional help does that require for us? That's why again, it's been no secret. I'm against the transfer. But I understand that if we're going to do it, we're intelligent people. There should be structure in the transfer, not we've dropped the ball, we're moving on.
Tell me, I missed this, forgive me. What is the timing of this transfer decision or implementation? I'm confused about that.
The discussion that's going on now is that there could possibly be a notice, if not concurrence to an opinion that comes out next month that says basically by July of 2027, the cases would become ours.
Less than a year.
Less than a year. Less than a year. So that would give us one session. And the fact of the matter is, they would state that it's a less big deal than we believe that it is. At the end of the day, you can look at their website. It represents about 60% of the work product that they put out into the world. So at very least, it's significant on top of a court that's already working, I would say, well above capacity.
You've told me something very important about the timeliness of this discussion. Thank you.
Thank you.
All right, any of the other judges have anything they want to say? All right, I'm sorry.
Clear. The division of labor between the two appellate courts is to a substantial extent a legislative decision. The Supreme Court has just two categories of exclusive appellate jurisdiction and a long list of categories of cases that are what we call their general appellate jurisdiction. That is subject to being moved back and forth from court to court by transfer. It comes the responsibility of the Supreme Court to construe the division of labors, construe the provisions set out as general appellate jurisdiction in application of a particular case. But there has been a tendency for them to very narrowly construe the cases that are assigned to them. At one point, they basically defined equity jurisdiction down virtually to nothing, and Justice Carley sharply called them out for an unconstitutional decision. The history of death jurisdiction is, I think, worth reviewing. When we were created in 1906, they divided up the labor based on what seemed important at the time. So we got torts and contract, and they got wills and property lines. The jurisdiction originally was for capital cases, the cases for which the death penalty was available, which at that time included not only murder, but kidnapping and rape and armed robbery, I believe, as well. In the 70s or 80s, case law removed the death penalty from the other capital cases. The phrase capital cases became obsolete. And so we got the current language about death penalty imposed or could have been imposed. When the Constitution of 1983 came up, there was a discussion, as there had been from time to time, the Supreme Court wanting to transfer its non-death murder jurisdiction, the Court of Appeals. And ultimately, there was a decision not to do that. And in her opinion, a few years ago, Justice Hunstein explained what the minutes of the Constitutional Convention said. And at the final committee meeting before it was submitted to the public, there's a colloquy between the Chief Justice and the Chief Judge and the Governor of Georgia agreeing that we're going to keep the status quo. The status quo had been since we were created. The Supreme Court handled all of the murder cases. And we have a recent opinion by the Supreme Court otherwise construing the statute. And I think if you respect the Federalist Papers, you ought to respect the minutes of that Constitutional Convention of 1983, which the Supreme Court decision dismisses as legislative history, which of course textualists disapprove of. So it's your call in my view.
Yes, sir.
Representative Reeves. One or two questions, I guess. The first is facilities. That came up, and it seems like that's something there's concern about, you have a new building. If you're adding a bunch of judges or staff, is there going to be room? I noticed in Arizona, they do statewide, they don't do districts, but they do have like one Court of Appeals office in Phoenix, one in Tempe, or somewhere else in Arizona. And, you know, with Georgia, there are some places everybody loves, Athens, Savannah, places like that. And there are other places where there might be centrally located, and central staff was one idea. I know Judge Dillard, I think, in addition to a couple of y'all, have talked about that, about central staff attorneys. If you grow the number of central staff personnel, would it make sense to have a satellite office somewhere and not have to change the footprint or build out the Deal Justice Center?
Some of this would have to come in, but as far as central staff, you would still need to build out specific for a chambers. If ultimately you would remove them and replace them with chamber space, I think that might be something in the future, especially if we want to maintain the concept that this is a 100-year building. That might be something to look at in the future. Right now, I would probably stay with the build out expanded space that's available now for chambers that's not unlike what we have now. But that could be something to absolutely do in the future, to look throughout the state. I mean, state of Georgia, the population center is Atlanta or close to it. So as far as having other population centers throughout the state, we've got them, but it seems that our model, at least the short time that I've been there, seems to be working with everything centered where we are. Now, I'm an hour and a half without traffic, which doesn't happen often. We do have folks that come from Albany. We've got folks coming from Savannah. I could see that someone similarly situated might say, it would be nice if we built facilities throughout the state. I would think that would be cost prohibitive, but y'all get to say that before I do.
Yeah. And, just historically, when they decided to build this building, there was an analysis about, should we have districts in Georgia? Should we break it up? And as opposed to you all running statewide, going to have a building here, a building here, a building here. They looked at the population, they looked where everyone was sitting, and they rejected that as being feasible for Georgia, coupled with the idea of, do we want different law in different parts of the state? If you live in Miami, the law there might be different than in the Panhandle. Then you're really relying on the Supreme Court. Are they going to fix that? I think we got a great system in Georgia the way that is. If you're thinking about like just putting central staff, some people on this part of the world, I think the majority of our staff still comes from the local area. And frankly, if they were going to be doing murder, and I'm going to now have 4 murder cases a term, plus reading 3 or 4 from the other 2 judges, I've got 12 cases. I'm going to want to see this person. So, is it feasible for them to be in Savannah? And then how am I working with that staff attorney? I want to have a little more access. I'm kind of a person who likes to see them all the time, and we do have, based on the pandemic, the flexibility to have a computer at home, and we can, if we need to, we can manage that way. But I think being in the building is better. I think if I were going to have 6 more central staff attorney, I'd rather have them on the 4th floor in offices than somewhere else.
If I could, I second everything she just said. She took some words out of my mouth. With respect to Arizona, they have 2 chief judges, 2 vice chief judges, separate locations, Phoenix and Tucson. And so whatever they call it, those look like two courts to me. And regardless of what we say, if I may offer an anecdote, I had an opportunity years ago in Texas to sit on a dais in front of a bunch of law students with a bunch of judges from around the country. And a Texas law professor was leading the discussion. I was sitting next to a colleague of mine who's a member of one of the Texas District Courts of Appeals. And the law professor said, anything that a District Court of Appeals court says is supposed to be law throughout the state. The justice, as they're titled in Texas, sitting next to me responded, look, I care about the 2 courts that can reverse me, my court and the Supreme Court. So dividing us up has that threat. I would note that a couple of our colleagues who have connections with local governments have managed to, who live further out, have managed to secure office space for a while in other buildings. Maybe that's a possibility, but I think it's really important we remain one club.
That will be. Chairman Smith?
Presiding Judge McFadden, you touched on something that I've reflected on since I heard about this unilateral shift that's being proposed. You mentioned something with the word federalist. Most of the judges on our Court of Appeals and Supreme Court are members of the Federalist Society, correct? Okay, other than you.
Well, I mean, I historically have belonged to both them and the Constitution Society.
Okay, and so, in just reading the statute, does it seem that this could be an activist way of reading the court's jurisdiction or lack thereof?
That is my view.
Thank you.
I do think from reading Hart, that decision, I think their perspective, whether we like it or not, or agree with it or not, is that that is what a plain reading of the 1983 Constitution says about jurisdiction. So I think at risk of saying what I think they would say, I think that's essentially what Hart says, and what I would imagine in whatever may come forth would be the same. They view it as not a choice necessarily, but a what the Constitution says.
And so there may be a division here on the opinion of what that actually states. It seems like I picked up some of that from just what little discussion we've had here today. And I'm thankful. I'd be interested in seeing the notes from the Constitutional Convention. One of my predecessors was probably heavily present in that conversation back in the early 80s. So I would be interested in seeing that. I mean, it's obviously, in speaking with practitioners around the state that have handled these sort of cases before the Supreme Court, there's not really a surprise from some of the practitioners that finally the shoe seems to be dropping here coming up within the foreseeable future. But, it's just an interesting perspective. And I appreciate you, Presiding Judge McFadden, for pointing that out.
If I may, I think that the basis for their rationale that now that the 83 Constitution changed the language from capital cases, as Judge McFadden was talking about, to cases in which death was or could be imposed, their rationale is that you have to give a death notice as the prosecution in a certain amount of time if it's going to be a death penalty case. And once that time passes and that notice isn't issued, which most of the time in a murder case now it's not, because we have the option of life without parole, that takes it out of that category. And so every other murder case, which is probably 98% of them now, becomes something not in that category. And that's their rationale for why, even though they've been voluntarily taking this out of just tradition, they don't have to, and it's not really their jurisdiction anymore.
Sure. All right, ladies and gentlemen, those of you in the audience, I don't want to ignore you. So if you have something you want to say or add to the conversation, we're happy to hear from you. We're looking for solutions.
And we've got Mike Terry on Zoom.
All right.
Dan Millman, I am the outgoing state bar adult practice chair. I'm a member at Stice Harbison. And in the past, I've worked in different size law firms, from solo practitioner to and 150 paying New England scale. And the reason why I say that.
Can you hear me now? Hopefully I was loud enough before. The reason why I bring some of that past experience up is to address the first request for salary improvements for both the court and court staff. I'm at a mid-sized firm currently. I say mid-size 170 attorneys in 6 states. We get to compete against the firms paying New York scale. I would feel very comfortable competing with the Georgia Court of Appeals for staff right now. I will just leave that as that is the disparity. It would be for many people, and especially younger law school graduates, that I am seeing come out with $200,000-$300,000 worth of law school debt. It would be life-changing money to move from the Court of Appeals as a 5th-year attorney to my firm. So I encourage the committee to think of that and support that increase in pay. Randomly going through, not randomly, I did not prepare a whole lot of remarks ahead of time. I wanted to hear what was discussed. I also anticipate, in addition to the reasons, and this was briefly touched on, in the increase in volume, I don't think it has hit the Court of Appeals yet. AI drafted pleadings are going to drive that. I am seeing it in my practice. I am seeing it. I am probably 60% trial court level. I am seeing many, many more AI drafted pleadings in the trial court. It is going to filter. It is going to be an exponential growth in this court. So as you are considering budgetary issues, staffing issues, please consider that. Please consider how we deal with it. Also, how we may need to deal with it in the Court of Appeals rules. The 11th Circuit and Georgia Supreme Court both have good mechanisms for conflicts checks at the beginning. I encourage the court, especially when looking at its own rules, to look at those, but in particular, the Northern District of Georgia and the 11th Circuit both have robust procedures. I particularly like the Northern District of Georgia's, where you identify certain people who are related to the case, file it as a separate pleading. Therefore, before you would even have to open a brief, you could see it before you even put eyes on it. I don't know that the sock ticker that's required in federal courts is necessary in the state court, but it may be another consideration. And I'm happy, I'll be at the reception afterwards if anyone wants to come and talk to me about these concerns. There was a question to Judge McFadden about, and I think to the judges generally, about may there be any tweaks to the Civil Practice Act or the Appellate Practice Act that might reduce volume. And I'm interested just in what the numbers might be on a couple of issues. Right now, under 91156, there's an automatic right of appeal of even a partial motion for summary judgment. How many civil cases are coming up to the Court of Appeals on a partial motion for summary judgment that might prolong the life of the case, that might be dealt with better at the end of the case? To the extent, and Rule 54 partial judgments that are sometimes directly appealed. Now, the problem with that is you're going to immediately see all of that pushed to the interlocutory appeal process. So if there is a change made there, I think there needs to be look at does there need to be an increase in staff attorneys to deal with that increase in volume? Because the water is going to go somewhere. But the question is, where does it go and how do we deal with it? The other thing I'd like to see is less cases making multiple trips to the Court of Appeals. And I'm sure that doesn't, that's something that
we concur.
And there are two areas, particular in my practice, I've seen this happen. One is where there are fee awards, whether under OCGA 91168, 91514. Perhaps looking at how that motion might affect the timing of a notice of appeal. We have a 45-day deadline for a 91514 motion and a 30-day notice for a 30-day deadline for a notice of appeal. That almost automatically creates a pressure to get the notice of appeal in before someone can move. And while the trial court can still rule on it, practice they rarely do. Even more problematic than that is, I believe, 91168, which right now has under case law, an end of the term deadline is undefined. So if you do have a 91168 offer out, the first thing you have to do when you get a judgment is calculate how many days do I have to get this motion in. The appeal doesn't stay it, but the motion can't be ruled under 91168D till the case comes back from the Court of Appeals, and that's an appealable order. So that's, I think, final thought is the ADR office. My experience with the 11th Circuit ADR office, it works because it's voluntary. It tends to work in certain classes of cases, especially, and I've done this both as a plaintiff and a defendant, but whether it's a defense verdict or a defense judgment, there can sometimes be a reasonable solution at that point. It's not going to get rid of everything, but I think for the Court of Appeals, every little bit that we can do to cut down on unnecessary work, dealing with cases too early, dealing with cases repeatedly, dealing with cases where there are parties who are willing to settle. But the other part of the 11th Circuit process that makes that work is it stays the deadline to file the appeal. So I think that is in the appeal brief. So, because if you're a defendant who's prevailed, part of your motivation to settle, if you can come up with a reasonable amount, it may be, hey, I think there's a weak judgment here, there's a weak order, I don't want to create a bad precedent, but I also want to save some money on appellate fees. And if we are pushing the parties to brief before it's mediated, you take a lot of that incentive to settle out. So those are my few thoughts. Thank you very much.
Representative Reeves.
Dan, thank you for coming. And it's that was really enlightening experience that you gave. Here's a question I've got. I know in insurance and the UCC and the fiduciary code, we had some updates that had not been done in a decade or two or three. In 5634, 5635, other key parts of the appellate statutes, doesn't seem like there's been a lot, you know, during my 23 years practicing in terms of when's the last time there's been some review on the statutes dealing with appeals. Is it kind of,
well, I mean, I don't know. My experience, and I'm hesitant to comment on this too much because I have a couple of cases before the Court of Appeals that are dealing with some of those application interlocutory issues. I think there was, for instance, there was a discussion about how much is coming up from a petition for review. And I do know it seemed like there was an intent in the latest amendment to 5634A to create, for instance, an immediate right of review for most zoning decisions. There was a recent Georgia Supreme Court case that said that with what was left in 5635, that appellants still have to file an application for a discretionary appeal of virtually every zoning case. So knowing what that intent was, I don't know. I don't know. That does bring me to another, this is a very particular issue that I deal with all the time. And sorry, not really responsive to your question, but I tend to end up with a lot of anti-SLAPP cases. I represent a lot of attorneys. Right now, the current, I think it's A14, 534A14, says that any appeal of an anti-SLAPP order is directly appealable. I have seen that, and this is kind of the nightmare scenario, get to the point of anti-SLAPP order issue, appeal, affirmed, Georgia Supreme Court denies certiorari, comes back down because appellate fees are available under the anti-SLAPP statute. You get a fee award, new appeal. So I would consider whether moving forward as a policy issue on something like that, do we want to say only specific orders under these statutes, such as only an order granting or denying a motion to strike, only an order doing this, only an order doing that. As far as some of the other topics, quite frankly, they don't really fit within my practice areas, but I do think it might be worth getting, once again, data from the Court of Appeals. How many of these cases are coming up? How many times are they coming up? And then does that require policy decisions?
Anybody else?
Thing about the data, and everyone's like, oh, we need more data. Our IT people are also overwhelmed in the world of working. And so if you request data from us, it may be something that takes a little bit of time. And I would defer to our clerk to talk about that. But I know that just when we were preparing for this, I was getting up, wait, we can't get you that. And I was like, I don't need it this Friday. Just get it to me in the next few months kind of thing. But we have a new IT guy who's been there how long? Almost a year, I guess. 1 year. And, so just want to point that out. So.
Yeah, and I do not want to in any way say that the Georgia Court of Appeals has not been doing as much as it can. This is the sort of thing that I think might even require, if you're going to really look at that sort of overhaul, bringing in some sort of independent entity to dig into the numbers. Because I don't think you would want to have permanent staff that would be doing it all the time or some sort of contract basis. It's, I would defer though to the clerk's office on that.
So we have an audit that begins. I'm sorry, a workflow study that begins on Monday week. So we hope that as a part of that analysis, they are going to be able to help us digest our numbers and even better understand internally our numbers and probably give us a better product to produce to you, because they are a consulting company brought from y'all probably dealt with them before, Guidehouse. I mean, I think that they've done some work with the DOC. They've done some work with different entities trying to come up with data, not just for you for the sake of giving it to you, but to give you reliable data. So that should start Monday week.
Mr. Chairman, if I may, just to acknowledge, you talked about the the discretionary appeal procedure. That's a kludge. When the Appellate Practice Act was passed in the mid-60s, it was removed. It was what we're imitating with the Superior and State Court Appellate Practice Act, and what we did with the Civil Practice Act, which was wipe away all these various writs that you got to pick among at your risk, at your peril, and just say, one form of action is civil action. Civil Practice Act, Appellate Practice Act said just a notice of appeal, 1-page document. And within 10 years, we came in with this other procedure that you have to file to a different tribunal, and you got to figure out at your peril which one you're supposed to use. And sometimes, unfortunately, changes to which one you have to use are actually codified elsewhere other than the Appellate Practice Act. And a lot of things, people are making obvious mistakes, but sometimes it's pretty tricky.
And it just a nuts and bolts thing that I'm embarrassed to even bring up in this office. Did you know that the Appellate Practice Act is not allowed for service money, unlike the Civil Practice Act? And so what we've done to make things work, about 8 or 10 years ago, we said, okay, well, if you tell us that you have an agreement with the other side, sort of by email, then we're going to do that. But technically, you're not. And that's a little administrative thing that causes a lot of hassle, because it doesn't, it's this extra thing. You gotta go say it the way I tell you to say it, or we're not going to docket it. There are a few things that, I mean, we don't docket. That's not our business. Sorry, but but that. So if somebody wants to sit down and help with nuts and bolts kind of stuff, that was great.
I know the people not in this room are having a hard time hearing you on that. So that's okay. We should have put a microphone in front of you. So, all right. Let's give.
AI, as soon as the family law case that came out a year ago where an attorney was caught using AI, I immediately created a statement similar to the word count statement that said, counsel certifies that something like counselor certifies that this brief was not prepared with any AI technology, whatever. I forget exactly what it was, but I don't know how that would help with the AI, make somebody think twice before using it. But I stick it on there anyway, is to let the appellate court know that I have not used AI.
Oh, this mic wants. Oh, gotcha.
I will say, along with the discussion of AI, we're constantly talking about the AI and the concerns that it's going to bring. One thing that we have done is prior to a couple of AI cases that we had come through our court, our sanctions were limited to 2,500. One thing we did do is increase our sanctions to 10,000. I don't know how much that's going to do, but that was done specifically out of concern over AI.
And we did also have a number of discussions about whether to do something like you suggested, whether to have a specific certification that, not necessarily whether AI was used, but at least, whether you verified what you're submitting. And we ultimately concluded that the existing rules already cover that attorneys should be verifying what they submit. Now that obviously pro se, it's maybe a whole different matter. Maybe there's something to think about there, but we did decide we didn't kind of want to get in the business of expanding, adding some additional specific to the broader responsibility professionally that attorneys have. And that we didn't also want to just be in the business of trying to decide, oh, you used AI, you didn't use AI versus this is just a garden variety typo, or so we made that decision, but it is certainly conversations we continue to have. And touching on earlier, I would say that in my assessment, and maybe our clerk would have, can correct me if I'm wrong, but I think that the proliferation of Gen AI certainly has added to both the volume of filings, but also has, made lengthier filings. So, let's be real, often the pro se filings were handwritten, pretty small, pretty easy to digest. They may not be the most robust arguments. Well, now a lot of those are coming in these very professional looking, lengthy Gen AI produced. So it adds, that adds to the workload. I don't know exactly what you do about that, but.
Can I add one thought on the certification and the ethical duties about AI? I agree with the decision that the court has reached so far that currently the rules and the ethics guidelines are adequate to address those. I'm sorry, the state bar rules. One thing that I would consider as things come before the court where you see AI use, just complete misuse of authority or citation to non-existent authority. I think that also falls within the state bar rule. I believe it's 3.1 about meritorious contentions and arguments. And that is a rule that, and the reason why I bring that up is not that everything needs to be immediately referred to the state bar, but one thing that I rarely see in orders, whether it's the trial court or from the Court of Appeals, is that if you are sanctioned for conduct under our state bar rules under 9.1 by any tribunal for conduct that would be a violation of the ethics rules, you as an attorney have an ethical duty to report yourself to the state bar. We are one of a minority of states that has that rules. And I think it may behoove those in robes that I will probably never wear in my life to remind attorneys that we have that rule when they enter sanctions, even if they're non-monetary sanctions. And that sort of trigger, to me, is much like the state bar rules in Rule 15 about overdrawing an IOLTA account. It's a canary in the coal mine. And when attorneys doing this and they're doing it in court, raising that, even if it's not to the level that it affects their license, it creates a record that this has happened where there's a disciplinary authority.
Any other questions? Yes, sir. You need a mic? Or you can go to the podium.
Stand.
Yes, sir. Got to press that button twice. There you go.
There you go.
I'm Robert Smith. I'm General Counsel of the Prosecuting Attorneys Council, and I'm an appellate lawyer. I've tried cases, but my home is in front of these fine folks, and their brethren in the Supreme Court. I've seen and heard a lot of these conversations. I'm aware of the law review article from 2014. If you haven't seen it, the Georgia State University has a law review article in 2014 talking about the modernization of the Georgia appellate courts. And some of those ideas have come to fruition. Other ideas are still up for debate. It's something I would encourage people to read. It's written by a very fine scholar whose wife happens to be a Superior Court judge in the Blue Ridge Judicial Circuit. One of the things I want to talk a little bit about is the increasing caseload is a direct result of COVID still. I know COVID ended years ago, but it's a train. Because if you remember, there was a period of time where we in the criminal world couldn't conduct criminal trials. We couldn't have grand juries. Y'all were very kind and helped us out to be able to keep the court moving. But when trials can't happen, things couldn't move. Once that opened up, that delay has led to trial judges who have dockets that are overrun. And the way to get out of that is to set trial weeks and trial weeks and trial weeks, to resolve cases, to have depositions, to do the things to release the pressure. Well, when you release the pressure at one point, it then causes the logjam somewhere else. And I'm going to borrow a phrase from one of your brothers, the hardest working intermediate appellate court in the United States is here in Georgia. These folks work really hard. When they go through distress, the lights are on in the deal building at midnight or later because they were all working. And that pressure is coming from the trial courts. We're going to see eventually it tamped down, maybe, because we're trying to get through that logjam, and that's where we're at. And as the Supreme Court has reduced its caseload in its jurisdiction, the question I have is the cert grants. Are we seeing an increased number of cert grants? Because if we're seeing that, then that's one of the ways to release the pressure, because they're then giving advice down. As to the original jurisdiction, moving that from the murder original jurisdiction, I can't say that all prosecutors are against that, but I can tell you that when we found out, because Sam Johntremont from the DeKalb office is here, when we got a panicked phone call in January from an assistant DA who had never argued before the Supreme Court, who had just received a brief from the Attorney General's office, or really the Solicitor General in the Attorney General's office, where they weren't filing a merits brief to discuss the Hart case. They were simply saying, you don't have jurisdiction to hear this case. We worked with that young man to get him ready to go in and argue, a point that none of us were prepared for. The associations were out of time, so we couldn't file an amicus brief to make our point known as a group. So we have never officially weighed in to that. But I will tell you, just from a personal observation, one of the things to consider is that there are 5 panels of the Court of Appeals. By rule, they do not have to be consistent. They usually are, but there are 15 individuals, very learned individuals. They like different things. What might be sufficient evidence for Judge McFadden may not be for Judge Doyle. And if he reverses a murder conviction, but she doesn't, we then have disparity. And both us and the defense attorneys are going to be having to ask the Supreme Court to weigh in and tell us which one works. There's no set amount of time for a cert grant to be ruled upon. So that's a victim's family that's in limbo. That's a defendant who's in limbo, waiting on the Supreme Court to decide whether or not to take a case up. Additionally, when a murder case is briefed to the Georgia Supreme Court, the Attorney General's office files a merits brief alongside the DA. under the code section that without duty is imposed, it specifically says the Supreme Court. So if original jurisdiction of murder cases flows to the Court of Appeals, all of those attorney general's briefs are no longer required unless you act. So the attorney general would have less responsibility and less assistance. And one of the things you may or may not be aware, Mr. Johnson is a very skilled lawyer. He works in an office that has extra resources because of the generosity of its county. Of the 51 circuits, maybe 10, 12
At most.
have appellate specialists. The rest of those offices clean what they kill. And I'm not talking about any of the solicitors' offices, by the way, who also have to do this. But the idea is that you're a trial attorney, and then after you try the case, you have to turn around and file an appeal. There's a blue ribbon panel committee that met 2 weeks ago, and one of the arguments was how awful and how difficult it is to shift your brain from trial mode to appellate mode, and why there's a need for appellate specialists. If we're moving murder cases down to the Court of Appeals, that's one of the things we're going to be seeing as more and more of a need for the DA's offices to have those appellate specialists. And the other thing too, the rules for oral argument are a little bit different for the Supreme Court and the Court of Appeals. And in a murder case, I would think that people would want to be able to get in front of the Court of Appeals and be able to argue. If you're talking about it having 2 terms to get your cases out, but suddenly your requests for oral arguments have shot up as well, the stress is not going to be 2 or 3 weeks at the end of the term. It's going to be more and more of months at the end of that term, where they're having because we as advocates are taking up the days and forcing them to work in the nights. And I'll stand for any questions.
Don't see any. Thank you.
Thank you.
All right, I need to, you have something? Tell us who you are and or
I'm a civil practitioner. Thank you. And thank you to Representative Evans for letting us know about the hearing today. I work at Kaplan Cobb, which is a boutique law firm in Atlanta. We do a lot of business litigation. And so I canvassed my partners for some thoughts on the topics today under discussion. And the main thing that came back to me was sort of a full-throated advocacy on behalf of the 2-term rule. Our clients really love it. We represent a lot of businesses, big national corporations, small local businesses. It's a very unique rule among the states. We practice in a couple of other different states, don't have the benefit of this level of predictability, of timeline. If we appeal this decision, if we seek an interlocutory appeal, we know how much time that's going to add to the case. If you're post-trial and trying to figure out whether to settle any of those many decisions that you have to make, the 2-term rule is really helpful to our clients. They love it. So does National Counsel that we work with as co-counsel. They're always very pleasantly surprised when we get to share the 2-term rule with them. So I just wanted to share that perspective. And it's obvious from the outside perspective how busy the Court of Appeals is. We appreciate the quality of opinions that we get from y'all, despite how much work you have to do. So to the extent you're looking for solutions, I would urge more resources and less pressure on finding ways around the 2-term rule, because especially for the business community, I think it's very helpful.
Yeah, thank you. All right, I know we have some folks online that have some questions. Mike Terry, are you there?
I am here.
Ah, awesome. You're
Wonderful.
recognized.
Thank you. Thank you. Really, most of what I wanted to say has been covered. I just want to make a few points. For many years, there has been a pipeline from law firms to staff positions on our 2 appellate courts statewide. 6 lawyers have left my firm in the last 30 years. And part of it is, just the pressure of billing hours, et cetera, to move to positions. And these are extraordinarily talented people to move to permanent positions with the Court of Appeals or Supreme Court. That pipeline has stopped moving in that direction. And if anything, it is moving the other direction. We get applications from the clerks rather than people wanting to go become the clerks. And I I don't think it's the pressure of the two-term rule. I do think it is salaries. So it is just a real reversal. And the type of people that we have who are top 10% in top 10 law schools and law review, and are now working for those courts on a permanent basis, that's not going to happen anymore unless the pay disparity gets addressed to some degree. To not as much the topic today, but the same thing I think is true of our judges. You know, I started practicing in a day where every appellate judge was, average 60 years old. And we're not seeing a lot of judges in that age range anymore with that experience anymore, not because certainly there's a push to appoint younger judges. I get that. But people are leaving when their kids go to college, honestly. And it becomes more and more difficult to justify to your family, to yourself about your family, the sacrifice that they are making for that public service as private pay goes up and as the judicial pay, creeps along. The disparity becomes greater, inflation eats away, and so we see that. I want to reiterate the corporate client and frankly all client admiration of our two-term rule. My corporate clients love it. They love the predictability. I love the predictability. I understand the pressure it puts on our courts, and I think an additional panel is going to have to be there. I watch the caseload carefully. I've been probably the most frequent flyer in the Court of Appeals on civil cases over the last 40 years, and I see what they do and what they have to turn around, and I'm astonished that they get it done. But just population growth is going to require another panel in the next 2 to 3 years based on what I'm observing. And then finally, I am not in favor of either of these two changes, but two things to think about if you're just trying to cut appellate caseload. That we have, as was mentioned earlier, the right to appeal even the partial grant of summary judgment on any claim, issue, or part of an issue or claim. Any minor grant of summary judgment goes straight up, although our Supreme Court has urged trial courts to keep the cases moving at that point. They don't. They use that as an excuse to stop the case almost uniformly. So you have a year's delay. And I understand it. I'm very happy to have those appeals frequently, but that's one way to cut it back. Another way, and this is a much smaller number, but it is complex cases, is we allow an appeal as of right from any class certification decision, whereas the federal courts require that to be an appeal by application. Again, that's just a few appeals a year, but they are very large and complex. So those are a couple of ideas for reducing the caseload. But mostly, I want to just speak in favor of increasing resources. What is happening with the resources available is amazing, but the quality cannot be maintained as the volume grows, both through just population growth and then the contemplated jurisdictional shift. So I think we have to move more resources in that direction, and anything anyone at our firm can do to help advocate that, please let us know.
All right. Thank you very much. Yeah, I don't know if Chairman Gullett is on with us or not. You know, he's not. Okay. All right. Next is John Haddon. Oh, there he goes.
Good afternoon. My name is John Haddon. I'm a civil practitioner in Atlanta, although I like to tell people I grew up on a farm outside of Augusta, so I don't get pigeonholed as an Atlanta lawyer. But I've been in practice since 2004, and I've been handling appeals since I think 2006 was my first appeal. And the first thing that I would say is the Court of Appeals, actually all of Georgia's appellate courts, Court of Appeals and Supreme Court, seem to be very well run from my standpoint as a practitioner. The vast majority of my cases are in the Court of Appeals. I've never had any sort of logistical issue. The only issues that I've ever had have to do with the trial court record, which is really a trial court clerk issue. The clerk's office at the Court of Appeals has always done an amazing job clearing that up. And these are cases with potentially tens of thousands or even hundreds of thousands of pages of records. I've litigated in the Court of Appeals, Georgia Supreme Court, 11th Circuit, U.S. Supreme Court, and actually had a case not that long ago in the Florida First District Court of Appeal. And the first thing I would say is, and I don't think anyone is really seriously considering the idea of district courts of appeals, but I would be very much opposed to that. In Florida, you really do end up with different courts. Supposedly precedent is precedent, but I was in the First District Court and I had a great case out of the Fifth District that sort of contradicted a case from the First District where I was. And I cited it at oral argument down there. And the court basically said, why are you citing us this case? We've already decided this issue. Well, I disagreed, but they looked at precedent on a district-wide basis. They didn't even know the judges in the Fifth District. And it became a much more difficult place to practice and also a much more difficult place to figure out what your law was. And I would also just say the Georgia court's rules are much clearer. The Florida appellate rules are much more convoluted, and there's a lot more discretion given to the court, a lot more uncertainty. Georgia rules, and I hear people who maybe are handling their first appeal and they say, oh, these rules are so complex, but they're really not. The Georgia court rules, Court of Appeals rules are pretty straightforward. So I would definitely commend our court for their procedures and the way that it is set up. In 2006, there was, I know Representative Evans made a point about there are a lot of decisions coming out right on the last day of distress and the last week of distress, and that's true. And I think that's something that could certainly be improved, but I think that it has improved vastly since I first started practicing. I recall being in the clerk's office, Court of Appeals clerk's office on the last day of distress. And I think the clerk was Bill Martin back in those days. And he was sitting there with a giant box of cases of opinions in envelopes at closing time. And he was going to drive those down to the late night post office to make sure that they got in the mail. I see our clerk now nodding her head because people don't believe me when I say that. But he said, yeah, we've got to get them out today under the constitutional rule. Obviously, that's no longer an issue because of the electronic filing makes that a lot easier. But the number of cases seems to be a lot lower that are coming out right around the distress period. It seems like, and part of this may be efficiency from electronic filing, but I think the clerk's office has managed to make things a lot more efficient as well. That has been a consistent improvement since I've started practicing, that the court operates very efficiently, very well from our standpoint at least. I will say there was a major concern in 2016 and 2017 when the appellate Court of Appeals jurisdiction was expanded that they were going to be taking on a lot more cases because of this expansion, the wills, domestic cases, and the other areas that were expanded. And in particular with the domestic cases, that's not just a case that goes up. That's a two-step process because those are discretionary. So you have potentially, my understanding is generally it's probably going to be two different panels, one looking at the application for discretionary appeal. Then if they grant it, it goes back down, you file your notice of appeal, goes back up, and it's probably going to go to a different panel. So you've got 6 judges at a minimum looking at those cases, which is, and just talking with the judges on the court, those cases are a big part of the caseload. And that was a big concern among practitioners, was whether the court was going to, not whether they were going to be able to keep up, but whether they were going to be able to continue with the high quality of output that we had come to expect. And it turns out that they did. Everything worked out. There was another panel added. But we have the same concerns now with the jurisdiction potentially being expanded to cover these non-capital murder cases. I know I talked with a lot of judges. Many of them are my friends here today on the court. I've spoken with some who are not here today. And I know that this is a big concern. And I believe what Chief Judge Brown said, that he's opposed to this jurisdictional change. I think that is, I don't want to speak for anyone, but that's the sense I get from other judges on the Court of Appeals as well. And it's not a conceptual opposition to handling murder cases. It's a resource issue that the court simply does not have the resources to be able to take on a significant number of new cases. I think the latest numbers I have, I think the Court of Appeals handles about 1,800 cases a year. Believe the Supreme Court is somewhere in the neighborhood of 270. And to shift a significant number of those to the Court of Appeals that already has the vastly higher caseload with less than twice the number of judges is certainly a big ask, and especially if there's no increase in resources. I know people who have been staff attorneys who have left, long-term staff attorneys, 20, 30 years with a lot of experience, and they simply can't justify staying there because of the pay disparity. So I think that is a big issue. And in talking with the judges, there is this real concern that there's going to be a continual drain of those staff attorneys because of the funding issues. And if the jurisdiction is increased, there's probably going to be a need for more of, and I may be using the wrong terms. I'm thinking of the central staff attorneys. The judges can elaborate on this, but someone to be able to take up that big caseload that comes in and make sure that continues to be handled efficiently with a lot more cases. I want to say that the Supreme Court has indicated, and maybe it would be 10 cases per Court of Appeals judge, something like that. I mean, that's 150 more cases per year. And these are complex cases. The Court of Appeals handles very complex cases as it is, as complex as anything that the Supreme Court handles. And a lot of times they're the same cases if they go up on cert. But in my practice with civil cases, we have cases 10,000, 20,000, 30,000 pages of record, and they have to, in a period of 2 terms, 8 months or so, go through all of those. That takes a lot of time, a lot of effort on the part of the clerks as well as the judges to be able to sort through that. So I agree with what the judges have said. I don't really have a stake. I don't do criminal law to know whether I would prefer to go to the Court of Appeals versus the Supreme Court if I had a murder case. I did talk with some criminal defense friends of mine, and the opinion was pretty divided. Most of them were fine with them going to the Supreme Court, but they also said if they go to the Court of Appeals, then that's fine too. Although I think that there is a concern, as one of our previous speakers said, that you are going to have 5 different panels as it stands now, deciding potentially very similar, the same issue, and sometimes they're going to decide them differently, and then that has to go up to the Supreme Court. So I think that is a continuing concern. One that I didn't think about that one of our speakers also mentioned was potential increase in oral argument. These days, it used to be that you were lucky to get oral argument. These days, it's a lot more common, in my experience at least. But if all of these cases, I suspect somebody who's got a murder case, they're going to want to get oral argument. Maybe there's a rule that they automatically get oral argument. Frankly, there probably should be, but that's going to put more strain on the court. So I think that covers pretty much everything that I wanted to talk about. Unless anybody has any questions, I appreciate your time.
All right, any questions for Mr. Haddon? Seeing none. Sarah Brewerton Palmer, are you here? Did she left? She did? Okay. All right, got her. I think that's it. Anybody else online that wants to speak? Not hearing anybody. Okay.
Rep. Silcox is on there, I think.
Is she on?
I don't know if she wants to speak, but.
We got listeners.
It's okay. They're just listening. All right. Anybody else in here? You got one?
Chairman, I had a House member, I don't know, they wanted me to identify him, but they said we need to cut down on the number of murders.
That goes back to the better class of criminals, you know. All right. Sure.
I am a young lawyer, but I do appellate criminal defense, and my interpretation of talking to my colleagues is that we would prefer the murder cases to stay with the Supreme Court. I feel like they have the capacity to do a little bit of a deeper dive with those cases, and I actually got the experience in my second year of practice to do an oral argument before that court on a direct murder appeal. And I feel like I agree with Robert that the oral argument piece of that is very, I think, important to consider as well, because I think in a lot of cases we would, in my practice, and I think my colleagues would be requesting oral argument in a majority of those cases. So just because I thought other criminal defense attorneys would be here to speak, but I hadn't heard any. So that's my preference and what I've heard from my colleagues.
Thank you.
And let me just say, in the Supreme Court, if you ask for oral argument on murder cases, it's absolute. We are application only, and we only grant about 30%. And if we have an increase in cases, it may go down.
Okay. Understood. Yes, sir.
Chairman Gunner, I wanted to mention Georgia Public Defender Council sent a lengthy letter. Appreciate Judge McFadden doing the analysis. Definitely, we welcome anything that anybody has from today that comes to mind that you've got insight and legal or statistical or any other insight. The door is open for you to follow it up from today.
Yeah. With the experience in this room, you're more likely to have a better solution than we're going to come up with on our own. So any ideas that you have, we greatly appreciate that and hope you would send that in to us. And I want to thank all the judges that came here, took time out of their busy schedules. You're not doing anything with cases today, so.
Right. We're all working on Saturday.
That's right.
That's it.
I appreciate y'all being here and of course, we're always open to any ideas from y'all and we will be having further discussions as we go. This will probably be the only meeting that we will do on this, but we still have time before we get into next session. If we need to have one, we can. If y'all come up with something brilliant, you find money somewhere, that would be great. And we'll take care of it then. So thank y'all for being here. Well, you want to tell them about the reception or?
Sure, we'll do that.
Okay. All right.
I do want to say that your interest means an awful lot. In the closing days of the last session, Judge Hodges reached out to Judge Gobill and I and said that he had bumped into Representative Evans and said, listen, would y'all be willing to meet with Representative Evans and Representative Reeves to specifically discuss these things? If we didn't go over that afternoon, we were there the very next day. Was it that afternoon? Next day. And that was, we sat down in an open legislative office outside in the foyer, and we were on sofas and had a very thorough conversation. And that conversation led to the discussion of having a next meeting. And to be quite honest, I thought most likely we were talking about meeting in the conference room at best. It became this. With this interest, and we certainly appreciate it. I feel like a lot has been accomplished. This is what's necessary for big moves, is the studies and everything that's necessary. We appreciate your interest. We appreciate the bipartisan nature of the interest. Thank y'all.
And thank you. I think libations go a long way in helping move things. So maybe we can do that again.
Second.
Yes, sir. All right, we're done. Thank y'all.